how would the protection of human rights within the United Kingdom change if the UK Human Rights Act were to be revoked? Well, in a sense, and there may be different options bandied about, but in a sense, what seems to be the leading proposal currently is to go back to before one had the Human Rights Act, before one had the Human Rights Act of 1998. And that was a period in which the UK courts were in a situation where the European Convention on Human Rights was not incorporated into UK law, as it is today. So they couldn't apply it in the direct way that the UK courts do today, and that the UK courts, it seems to me, do very well today. Instead, the UK courts would rely on domestic concepts of fundamental rights, drawn, of course, from the common law, from the very rich repository of the common law, but also in applying those common law rights, so those homegrown rights, the court, before 1998, would look to other extraneous instruments, such as the European Convention on Human Rights, which would indirectly, if you will, come in or enter the scene and shed light on certain aspects of English law, of UK law. But a problem, as many judges pointed out, a problem with that situation, and this was really found to be most unsatisfactory on the part of the UK judiciary, was that given that the UK was a member of or a party to the European Convention on Human Rights but hadn't incorporated it, it was possible for UK citizens to take their case to the Strasbourg Court, to the European Court of Human Rights at Strasbourg. And in that pre-1998 period, this would of course happen then without the UK judges having had, as one of them put it, their bite of the cherry, without the UK judges having had the opportunity directly to review the case in terms of UK human rights obligations under the Convention, and to say why it was that the UK was or wasn't in breach of a particular provision of the Convention. And that, of course, is important when the case goes to Strasbourg, because under the principle of subsidiarity, which says that that which can be done locally or nationally is not to be done at a European or international level, the Strasbourg judges didn't have very much to sink their teeth into in terms of how their UK colleagues had looked at the matter or had thought of the matter. So the Strasbourg court then, and this was seen as being rather unsatisfactory from Strasbourg too, the Strasbourg judges would look at the matter in terms of the Convention rights with very much fresh eyes. Whereas today, in the situation where we have the Human Rights Act, it's very different. UK judges are bound to apply the Convention and do so that when, in the relatively exceptional case, the applicant doesn't receive succor in the UK courts, takes his or her case to Strasbourg, and the Strasbourg court is ready to, or deems the case meritorious, then the Strasbourg judges will be able to rely on how normally, numerous instances of UK courts had viewed the matter, and to build on their assessment of the facts, which is very important in this connection, and to build often also on their assessment not only of UK law but of the Convention. So what you have under the current setup with the Human Rights Act is a situation in which the domestic judges and the European judges, if you will, are bound to work together. That was different to some extent before 1998, and that would be different, it seems to me, if the Human Rights Act were to be revoked. Would the United Kingdom automatically be in breach if it were to revoke the Human Rights Act? Well, that would depend on the manner in which the government were to revoke the Act, because there's nothing in the Convention that says that you are bound to incorporate the Convention into domestic law in order not to be systematically in breach of it. It is perfectly possible for a state, as was the case with many states, until typically the 70s and 80s and 90s, it is perfectly possible for a European state to be a member of the European Convention without having incorporated into its domestic law that convention, simply because whether you are in breach or not is basically a question or a matter of the bottom line. Has a country breached the right to freedom of expression? Has it breached the right to an individual of privacy and family life? That's really the nub of the matter, not whether one has incorporated the convention into one's domestic law or not.